installment of the Environment Office's weekly webinar Wednesdays. I'm Karina Serta, the Communications Associate with the Environment Office. Tonight we're joined by Cathy Guirguis of OKT Law, who will be providing us with an update on the land claim. After Cathy has given her update, we have a few questions that we've heard from members that I will ask her to answer. So now I'll pass it over to Cathy, who's joining us online from Toronto. Cathy, thanks for joining.
Thanks for having me. So thanks for the introduction. As you said, my name is Cathy Guirguis, and I am one of the lawyers at OKT Law in Toronto that is working right now on the Saugeen Ojibway Nation's land claim. And I'm here today to give you an update about the Saugeen Ojibway Nation land claims that's currently being argued in the Ontario courts. So the first thing I want to talk about is what this case is about. There are two main claims that are being brought forward. The first is the Aboriginal title claim, and the second is a claim about Treaty 72, the 1854 treaty that surrendered the Saugeen or the Bruce Peninsula to the Crown. So the first claim, I'll give you a brief overview of what the Aboriginal title claim is referring to. The Aboriginal title claim is a claim of an ownership interest for the court to grant a declaration of Aboriginal title over the beds of the waters that make up the Saugeen Ojibway Nation in Georgian Bay and Lake Huron. So you may have seen a map previously in previous updates from the Sawn Environment Office that illustrates the traditional territory of the Saugeen Ojibway Nation and what that includes. That sets out the boundaries of what's being claimed in the Aboriginal title case. So the part of Lake Huron is about 11 miles south of Goderich, heading straight out to the international border, and north along the border to the midpoint of the channel between the northern tip of the peninsula and Manitoulin Island, then across over to the middle of Georgian Bay and back down to hit land east of Collingwood. So seeking Aboriginal title, which is a Section 35 Aboriginal rights, something that's recognized in the Constitution. That's a new idea in Canadian law. The Supreme Court of Canada has made a declaration of Aboriginal title to lands in the past, but this will be the first time, if we're successful, that a court has to decide about Aboriginal title to a body of water. We're seeking the claim against Canada, Ontario in this part of the case. And what we expect, or what we know that Canada and Ontario are going to be arguing, is that it's impossible for an Indigenous nation to hold title to the bed of a big body of water like Lake Huron and Georgian Bay. Essentially, they say that this idea or this kind of declaration can't fit in Canadian law because it can't coexist with Canada's sovereignty. We think this is wrong, and the arguments that we're going to be making in response to this is that there are other places that have similar legal systems like New Zealand, where the courts have had no problem finding that Aboriginal title exists to beds of the ocean. And we think, and we will be arguing, that the same approach works here too. So the evidence that we have in the Aboriginal title case is about showing that the Saugeen Ojibway Nation controlled and used these portions of Lake Huron and Georgian Bay, leading back all the way back to 1763 and up to present. So why 1763? In 1763, this is the date that British claimed sovereignty over this area of what we now call Canada. And in Canadian law, that's kind of the magic moment for assessing Aboriginal title. It's a bit artificial, but that's the test that we have from the Supreme Court, saying that you need to demonstrate at the time of the assertion of sovereignty that you're exclusively occupying the area. And that's what you need to meet in order to say that there's Aboriginal title, or there was Aboriginal title there. So we're also putting in some evidence in addition to that, in addition to evidence about the use back at that magic moment in 1763, we're also putting in evidence and hearing evidence about Sawn's relationship with the territory today. Because the relationship that Sawn members have with the territory has been around for a long time. This will help the court understand the Sawn's relationship to the territory that's being claimed in 1763. So that's the first part of the claim. The second claim is the Treaty 72 claim. So this claim is about the Crown's broken promises to the Saugeen Ojibway Nation. And the story of this part of the case starts in 1836. In 1836, Lieutenant Governor Bondhead told the Saugeen chiefs that white people were coming and there was nothing that they could do to stop them from taking Sawn's land, from taking the Saugeen Ojibway Nation's land. But if the Saugeen Ojibway Nation would give up their land south of Owen Sound and move to the peninsula, the Crown promised to take care of and protect those lands forever for Sawn. So that's not what happened. 18 years later, the Crown came back in 1854 seeking a surrender of the peninsula. In the time in between, what happened is that there was an influx of squatters and settlers that came onto Saugeen lands on the peninsula, and the Crown said they could do nothing to stop them. That the only way to protect the Saugeen Ojibway's interests at that point is that they needed to surrender the rest of their territory and keep smaller reserves to themselves, and then they could sell the lands for their benefit. What we're saying in this claim is that that wasn't entirely true, is that the Crown could have done more and should have done more, enforcing its own laws to remove people and to make sure that it kept its promise. So we're arguing that that this entire thing is a breach of the Crown's fiduciary duty that it owed to Sawn, and that it led to Sawn losing most of the peninsula in Treaty 72. So what we're asking for in this part of the claim is we're asking to get what lands we can back for Sawn. So the way that we do that in law is that we're seeking a remedy that's called a constructive trust. And what that means is basically any lands that the Crown still holds, we're saying that because the Crown did something wrong, because it breached its duty, that any lands that it still holds that haven't been sold to third parties, and I'm going to come to a minute in this about what I mean with third parties and how that's dealt with too in this claim. But whatever lands that the Crown still has, national parks, other kind of like Crown lands that they still have, because they breached this duty, then what we want the court to find is to say, well, those lands that the Crown still holds actually is held for the benefit of Nawash and Saugeen. But when it comes to lands that are already in the hands of private properties, we're just seeking compensation. Because at Canadian law, if there was a third-party buyer of lands and they didn't have notice of the claim, then Canadian law doesn't let us recover those lands. So in this case, we are against Ontario, Canada, and the municipalities on the peninsula. Why the municipalities? Because the municipalities at a certain point in time, they received without having paid for it. So it's different than the third parties that paid for these lands. They received unopened road allowances and shore road allowances. They received that by virtue of legislation from the Crown. So they were kind of gifted that and said, you're responsible for these. You have to open up roads on these and so on and so forth. So we're saying because those weren't bought and paid for, that those also should be returned to the extent possible that they can. So that's why the municipalities on the peninsula are named. So the claim under the Treaty 72 claim is against Ontario, Canada, and the municipalities. There's also another second issue in the treaty case, which is about showing that Sawn's harvesting rights, or asking for a declaration confirming that Sawn's harvesting rights were not affected by Treaty 72. That whatever rights that they had to harvest throughout the territory at that time were not affected by Treaty 72. So that's a basic overview of what the two claims are about. Well, where are we at in this case? So we started in April of this year with opening statements in Toronto, and then we came out to the communities for 1 week each. We came out to Saugeen for 1 week, and we came to Nawash for 1 week, or shorter than 1 week, because we moved a lot faster than we thought with the witnesses. And we heard from some of the witnesses, traditional knowledge holders, and also lay witnesses, people that had experience with the claim and had experience and talked about the assertion of Sawn's rights over the years. So that started in April, that process, and then we've been sitting in trial throughout the summer. We have breaks here and there. And right now we are just in the process. This week we'll be finishing entering our evidence through our expert witnesses this week. So some of the witnesses that we've heard from, we heard from former Chief Vernon Root. We heard about how the court, how Sawn had historically controlled its territory, about how the Sawn helped push the Haudenosaunee out of the territory in the late 17th century, about the spiritual aspects of the waters in Sawn's territory. We heard from Carl Kishik, who told the story about the creation story and the story of the flood, and how these stories help the court understand Sawn's relationship to the territory. We heard from several experts. We heard from Ron Williamson, an archaeologist that gave evidence that Sawn has been in its territory since at least the end of the Ice Age, 13,000 years ago. And also that Sawn had to leave its territory during the Iroquois Wars around 1650, but returned as early as the 1660 and has been there since. And he discussed the archaeological evidence around that. We've heard from a historian, Professor Jarvis Brownlee, who gave evidence about the negotiation of Treaty 72 and how it was the result of constant pressure and threats about not being able to protect the peninsula. We heard from Marianne Corbière, a professor of Anishinaabe who testified about how the Sawn would have understood the promise to protect the peninsula forever. And I'm just giving you kind of a select few. I'm not going to go through everyone because we will be here all night discussing what we heard from all of the witnesses. And then this week, we're hearing from Professor Dribbin. He's testifying this week about how Sawn and the Anishinaabe would have understood the treaties, about how the Anishinaabe, how the Saugeen Anishinaabe would have controlled their territory historically, including its water territory. So he's currently testifying right now, and he'll be finished with his testimony tomorrow. So after we finish the evidence, once we finish the evidence that we're leading, then the plaintiffs close their case. So what that means is that we stop leading evidence. We still have a few witnesses to come and reply evidence that will come after Canada and Ontario lead their case. But what we do is we close our case now. And Canada, the next step will be that Canada next week will deliver a short opening, and then they will call their own experts forward to bring evidence. So they're going to start bringing forward their evidence about the case. So we expect, and we understand from Canada's opening statement, they gave a brief one in April. They're going to give a longer one next week in Toronto. That they're going to bring evidence that say that Sawn did not use the waters of the traditional territory in a way that can justify an award of Aboriginal title. They probably will say that the lake beds were too deep, the waters were too dangerous to occupy it sufficiently, such that a declaration of Aboriginal title was required. They're probably also going to bring evidence and have their experts talk about how the population was exploding. The Crown did the very best that they could to keep squatters off of the Saugeen Ojibway lands, but that they had no choice but to take the surrender in Treaty 72. So Canada will be leading its evidence until the middle of January. Then Ontario will lead its case and bring forward its expert witnesses. And then followed by the municipalities, which I think they have one expert, and then they'll be, and they'll just have a short piece in this case as well. Then we'll have a break in the trial after that. After that, then we will bring our reply evidence, which will probably be about 1 week. And we expect that to take until the spring. Then we'll have a short break in the trial of a couple of months where we put together the final legal argument. Then we'll convene again and we will make our oral closings to the judge. And then she'll take a break to write her reasons. So all of that to say is that by spring of next year, of 2020, we expect that everybody will be finished putting in their evidence, and then we will have some kind of schedule for hearing closing arguments. So one thing to note is that what I'm talking about right now is phase 1A of the trial. And this relates particularly to the treaty claim. So we've already talked about the treaty claim, the Treaty 72 claim about the surrender. That part of the trial, that part of the claim, not the Aboriginal title claim, but that part of the claim is phased. And there's phase 1A where we're dealing with liability, where we are making the arguments to the court to say that Canada and Ontario are on the hook for this breach of fiduciary duty. And we want the court to make a decision about whether there's liability and also whether it's available to us that we can get a constructive trust over Crown lands. So that's phase 1A, and phase 1B is figuring out if the constructive trust is available in relation to these parcels. Then phase 2 would be about remedies generally, and that's about figuring out how much compensation would be due for lands that aren't being returned, and what particular lands would be subject to, like what particular schedule of lands that the municipalities hold would be subject to this constructive trust. So how long 1B and 2 will take is another question that I don't have the answer to in this update. That might take much longer, and they might never happen, because it might be that if we're successful in this part, things just go to a negotiation table, which is often the case in these kind of cases. I just don't know quite what that will be. So that's essentially where we are and what we expect in terms of timing for the two claims. So at this point, I think we can go into, I can answer some questions if you have any questions about that.
Yeah, that's great. Well, thank you very much, Cathy, for the overview. It was a great update. We just have a few questions here from members. So the first one was, you touched on this a bit, but just to clarify it a little bit more, when will the case be over?
So yes, that's what I was trying to touch on at the end, and it is a difficult thing to say for sure. But I expect that the first phase of the trial, as I said, will likely end by next summer. That's not including the time that the judge will need to write a decision. But there's still the 2 more phases. So it may take quite a bit more time, even if for a few more years, before this is finally resolved. And in addition, if we're successful even on the first phase, the Crown may decide to appeal. And that could take some time to resolve. That could take a couple of years or whatever it may be. Also, if we're not successful, which is also a possibility, we would appeal, right? This is the kind of case, because of the precedent-setting nature of this case. It's never been done before, that this is probably going to go up in appeal. So that also creates some delay. So I guess the answer is, when will the case be over? Difficult to say. We think phase 1 by next summer, but then we have to account for other mitigating factors as well.
Okay, great. Yeah, that's a nice answer there. More complete. The next question that we had from our members is, are there going to be any more hearings in the communities? How can Sawn members watch the trial?
Okay. So that's a great question. So the community hearings that we had in May, that was back in May and June, I believe. We had some of the community knowledge holders testify at that time. There's no plan right now, unfortunately, for any more sittings in the communities. The reason for this is it's actually quite difficult to move the court. We had to work out a lot with the Owen Sound courts to borrow electronics and to get everything set up in the community hearing. So it was great that we were able to do that, but because we're running a trial that has thousands and thousands and thousands of documents, everything has to be done electronically. We have real-time transcripts coming up, so it is a bit difficult to manage. So there's unfortunately no plan right now to get the court to make another trip, but the court is always open to the public, and especially to Sawn community members to come and watch the court. I think there's a sign up that says that there's maximum seating of 34 people, so which is great. We have a large courtroom in Toronto. The address of the court is 330 University Avenue. It's on the 5th floor, and it's courtroom 5-1. So that's always a possibility, is that it's open for any community members that are in Toronto to come and attend. And we can provide information. The schedule is often changing, but we are pretty easy to get in touch with at OKT, just by sending an email to our general info@oktlaw.com. You can get some information about what the trial schedule is for that week.
Okay, great. That's awesome. The third question that people had is Sawn going to get land back as a result of the case? And I know you've touched on this one a bit as well, but you have to round that out a little bit more.
Absolutely. So the short answer to that is maybe. That's the hope. That's what we're seeking in the treaty case. That is the #1 priority. there's the risk that the judge is going to decide that that even if the judge decides that we are right, that the Crown breached its fiduciary duties to the Saugeen Ojibway Nation, that even if we're successful in that, and that is a big if, as it always is with court, that it won't want to award the return of lands. And instead, they'll say compensation instead. She'll say that compensation can make it right. The reason for this is that this is a possibility is that, the lands that, while we're saying that the Crown lands should be held in a constructive trust and held for the benefit, and maybe those legal arguments are sound, the practical reality is that this is, again, something that's not necessarily been done on such a large scale before, that, a judge often has to consider practical interests and what that would mean outside of that. So we think that we have a good argument for it, but we don't know for sure how things are going to roll out, and how things are going to end up. So and it's also important to note is that even if we're successful on the remedy part of it, and the judge does agree with us that the Crown lands are held as a constructive trust, we're only going after those lands that are held by the Crown, by Ontario, Canada, and the municipalities' lands that they did not purchase, but were given road allowances and shore road allowances. Canadian law won't let us disturb the title or the ownership of private landholders that have paid for it.
The next question that we have is, how is Aboriginal title different from the commercial fishing right Sawn already has around the peninsula?
That's also a really good question. We mentioned earlier that there's never before been a case like this in Canada. There's been claims for Aboriginal title, but this is the first one that's a court that's come to argument in court, and now if the court does decide that Aboriginal title, that we are, that there's to make a declaration of Aboriginal title to water, this will be the first time that it happens in Canada. So what would that mean? Aboriginal title, when it comes to land, is like ownership. So having an Aboriginal title right to land is like ownership. It's the right to decide how the land will be used, the right of enjoyment and occupancy of the land, the right to possess the land, and the right to protect it for future generations, right? So that's a restriction that exists on it, is that you can't use it in a way that prevent future members of the group from enjoying it too. So that's what we know about Aboriginal title when it comes to land. So on water, it would be the same, right? You would have that same right to decide how the land would be used, or the water would be used, the enjoyment and occupancy, and so on. But you have to figure out how it also interacts, because you have to do this with Aboriginal title to land too, how it interacts with the rights of the way to enjoy the waterways, right? So especially on water, you have to figure out the general public to enjoy the waterways, public rights of navigation, and so on. So you might get ownership rights subject to general public use for things like boating or national security, things like that, right? So in any event, it will go beyond the right to manage and benefit from the fishery. It's likely to include a right to benefit from and manage other aspects of the lake and Georgian Bay. But details of that, we just don't know yet. And it's likely that the details may need to be worked out through negotiation. So the specifics of how decision-making might work in relation to the land, to the waters that are subject to Aboriginal title will need to get resolved. That's certainly the case in what happened when the Supreme Court of Canada made the declaration with respect to Aboriginal title for the Chilcotin Nations out in BC to land. After that, even after that success, they went into negotiations and had to sort of resource management might be one option, but again, I suppose that we just don't know as of yet, because this is something, again, that's new. We have ideas of what it might be, and joint management or joint resource management might be something that is a model that's out there, but we don't know yet.
Okay, great. And the last question that we have for you is, will Sawn members get compensation if the case is successful?
So if Sawn is successful in the case, if we're successful, then one of the things that we're asking, particularly as a two claim, is compensation for lands that aren't returned and for lands that die in those lands. So, like I said, that's something that the amount of compensation is not going to be determined until a later phase of the trial. But if we're ultimately successful in the case, then compensation may be awarded. It will be for the First Nations, the two First Nations, Saugeen and Nawash, to decide how to allocate that compensation and how they want to use that for the benefit of their communities. But yes, so the asking, the seeking of a compensation award, though, is part of this case, just not going to be determined until later.
Okay, all right. Well, that's great. Thank you very much for the comprehensive answers and the overview. We really appreciate your time in joining us, Cathy, and we hope you have a good rest of your evening.
Great. Thank you so much. Thanks for having me. Bye.
Okay. Thank you, everybody, for watching as well and for participating in the call. If you have any questions for us, please feel free to submit them on our Facebook or on our website.